Hello everyone, my name is Manvi and today I am going to tell you about the sources of Muslim law. Muslim law is a personal law which is applied only on Muslims. It is applied by courts in India to Mohammedans, not in all, but in some matters only. Muslim law in India means that portion of Islamic civil law which is applied to Muslims as a personal law. Muslim law is a body of law which is derived from the Quran and other recorded sayings of the Muslim prophet Muhammad. However, Islamic law talked about man's duty rather than his rights. In the righteous sense, Islam means submission to the will of God, and in secular sense, Islam means the establishment of peace. The origin of Muslim law is Arabia, where Muhammad inculcated Islam. The object of Islam is to create a sense of obedience and submission to Allah, His ordinances, and thereby to walk on the right path. Those who follow this path are Muslim. According to Amir Ali, Muslim is any person who professes the religion of Islam, in other words, accepts the unity of God and prophetic character of Muhammad. Thus, to be a Muslim, only two things is required. One is that Allah is one, and the second is the prophethood of Muhammad. Muslim law consists of the injunction of Quran, of the traditions introduced by the practice of the Prophet, of the common opinion of the jurists, of the analogical deductions of these three. Further, it has been supplemented by the jurist preference, public policy, precedents, and independent interpretation. Now, let's see the sources of Muslim law. The sources of Muslim law are divided into two categories: primary source and secondary source. Primary sources are those sources on which Muslim law relies on. These sources are the foundation of Muslim law. The primary source includes the Quran, Sunnat, Ijma, and Qiyas. Next is a secondary source. These sources are not basic sources of Muslim law, but the supplementary sources of Muslim law. The secondary sources of Muslim law are customs, precedents, legislation, justice, equity, and good sense. Now let's let's talk about the primary source of Muslim law. First is the Quran. Muslim law is founded by Al-Quran, which is believed by the Muslims to have existed from eternity, subsisting in very essence of God. The word Quran has been derived from the Arabic word Qura, which means to read. The Quran is Al-Furqan, that is, one showing truth from falsehood and right from wrong. The word Quran, which is the divine communication and the revelation to the Prophet of Islam, is the first source of Muslim law. Quran is the primary source of Muslim law in point of time as well as in importance. The Islamic religion and Islamic society owes its birth to the word of Quran. It is a paramount source of Muslim law in point of importance because it contains the very word of God, and it is foundation upon which the very structure of Islam rests. Quran regulates individual, social, secular, and spiritual life of Muslims. It contains the very word of God as communicated to Prophet Muhammad through angel Gabriel. It was given to the world in fragmented forms, extended over a period of 23 years. It originally had for its object repealing objectionable customs such as usury, unlimited polygamy and gambling, etc., and affecting social reforms such as raising the legal status of women and equitable division of the matters of inheritance and succession. The Quran can be no way altered or changed, thus, even the courts of law have no authority to change the apparent meaning of the verses as it does have an earthly origin. Now let's talk about the Sunnah. The word Sunnah means the prudent path, and this meaning shows it donates some kind of practices and precedent. It is belief of Muslim that revelations were two kinds. Manifest means zahir and internal means batin. Manifest revelation is communicated which is made by angel Gabriel under the direction of the God to Muhammad in the very words of God. Quran is imposed of manifest revelations. Internal revelation is opinions of the Prophet which is delivered from time to time on questions that happen to be raised before him. Sunnah means the model behavior of the Prophet, the narration of what the Prophet said, did, or tactily allowed is called hadith or traditions. The traditions, however, were not reduced to writing during lifetime of Muhammad. They have been preserved as traditions handed over down from generation to generation by authorized person. The importance of hadith as an important source of Muslim law has been laid in the Quran itself. Next source is the Ijma. It, it was equally binding on the people to act on a principle not contrary to the Quran or Hadith, which has been established by agreement among highly qualified legal scholars of a generation. Ijma has been defined by Sir Abdul Rahim as agreement of the jurists among the followers of the Prophet Muhammad in a particular question of law. The validity of Ijma as contained a binding precedent is based upon a hadith of the Prophet which says that God will not allow his people to agree on an error. Ijma thus become a source of law. The authority of Ijma as a source of Muslim law is also founded on Quran and Hadith. The law is something living and changing. The aim of law is to fulfill the needs of the society. Now let's talk about the Qiyas. This is the last primary source of Muslim law. Qiyas means reasoning by analogy from above three sources Quran, Sunnah and Ijma. In Qiyas, rules are deduced by the exercise of reason. Qiyas may be defined as a process of deduction by which the law of the text is applied to cases which, though not covered by the languages, are governed by reason of text. Thus, it should be noted that Qiyas does not prove to create a new law, but merely to apply old established principles to new circumstances. There are some conditions for the validity of Qiyas. First condition is that the original source from which Qiyas is deduced must be capable of being extended, that is, it should not be of any special nature. Second condition is the original order of the Quran or Hadith to which the process of Qiyas is applied should not have been abrogated or repealed. Third condition is the result of Qiyas should not be inconsistent with any other verses of Quran or any established Sunnah. Fourth condition is Qiyas should be applied to ascertain a point of law and not to determine the meanings of word used. Fifth and the last condition is that deduction must not be such as to involve a change in the law embodied in the text. Thus, it can be said that Qiyas is a weak source of law, and rules analogically deduced do not rank so high as authority as those laid down by Quran and Hadith or by consequences of opinion. The reason is that with respect to analogical deduction, one cannot be certain that they are what the lawgiver intended. Such deduction always rests upon the application of human resources, which always are liable to error. Now let's proceed toward the secondary sources of law. The first secondary source of Muslim law is custom. Before the emergence of Islam in Arabia, customs were the basis of entire social life, religion, morality, trade, and commerce. Custom has not been recognized as a source of law in a Muslim law. However, it cannot be denied that custom has always been given a place under Muslim law if it is in conformity with Muslim law. For example, Prophet Muhammad never repealed the whole of the pre-Islamic customary law of Arabia. In various matters of Muslim law, custom plays a significant role when the matter is relating to their agricultural land, testamentary succession among certain communities, and charities other than the Waqf, because these matters have not been included in the Section 2 of the Shariat Act 1937. Custom influenced the growth and formation of Sharia in several ways. First, a number of texts, particularly traditions, are based upon usages. Second, a part of the Sharia based upon tacit or silent approval of the Prophet comprises many of Arab customs. Imam Malik says that the customary conduct of the citizens of Medina was a sufficient ijma to be relied upon in the absence of other texts. For a custom to be valid, there are some preconditions. First condition is custom must be a territorial. Second is it must be existing from memorable time, that is, it must be ancient. Third is it must be continuous and certain and invariable. Fourth is custom should not oppose the public policies. Fifth and the last is custom must not in contravention of Quran and Ijma. Now let's proceed towards the precedent. This includes the decision of Privy Council, the Supreme Court and the High Court of India. Judges explain what law is. These decisions are regarded as a precedent for future cases. Judicial decision is one of the distinguished characteristics of English law. In India, the plan of Warren Hastings of 1772 made provision that it was only judiciary which introduced new set rules in personal laws of Hindu and Muslim. Now let's see the next source of Muslim law. Legislation. In India, Muslims are also governed by the various legislation passed either by the parliament or by the state legislature. The following are the examples of the legislation in India. Religious Toleration Act, Freedom of Religion Act 1850, the Mussalman Waqf Validation Act 1930, the Shariat Act 1937, and the Dissolution of Muslim Marriage Act 1939. These acts have been considerably affected, supplemented, and modified the Muslim law in 1986, an act that is Muslim Women Protection of Rights on Divorce Act 1986 provides separate law in respect of divorced women was enacted by the Indian Parliament. According to need of time and circumstances, Indian legislature enacted the law to fulfill the needs. Now, the last source of the Muslim law is equity, justice and good conscience. The doctrine of equity, justice and good conscience is regarded as one of the sources of Muslim law. Abu Hanifa, the founder of the Hanafi sect of Sunni, expounded the principle that rule of law based on analogy could be set aside at the option of the judge on a liberal construction or jurist preference to meet the requirement of a particular case. These principles of Muslim law are known as istihans or juristic equity. Istihan literally means approbation and may be translated as liberal construction or juristic preference. This term was used by great jurist Abu Hanafi to express the liberty that he assumed of laying down the law which in his discretion the special circumstance requires rather than the law which analogy indicates. Several areas of Muslim were modified so as to meet the changing conditions in India. Now the conclusion. These four sources, namely Quran, Sunnah, Ijma and Qiyas, are the primary sources of law. Muslim law mainly based upon verses of Quran and practices of Hadith. There is secondary source of Muslim law which subsequent of it. Sects of Shias does not accept the Qiyas as a source of Muslim law. It is due to the contribution of all that an orderly and systematic theory of personal law of Islam came into existence which governs the Muslim community. Thank you Hope you have liked the video.